morning, good afternoon, everybody. Welcome to our tax section program today on the Pandora Papers, Behind the Headlines. Before I introduce the program, I want to take a few moments to thank our section sponsor, Hockman, Salkin, Tasha, and Perez. They have been a sponsor of the section for a very long time, and we appreciate their continued support for the tax section. So I want to focus now on our meeting. So welcome, everybody. Today, we're going to talk about the Pandora Papers. As you know, it was a major leak showing that many celebrities and very wealthy and public people have been putting assets offshore. And we're going to discuss today the issues involved. Is that a problem? Why do people do this? And can there be any tax enforcement repercussions? And I'd like to introduce our illustrious panel of specialists. Jeff Verdun, who is the managing partner of Jeffrey Verdun Law Group, has been practicing in the areas of taxation and comprehensive estate planning since 1979. He is a specialist in asset protection and has extensive experience working with foreign offshore investments and trusts. And Craig Redler, who is also an attorney working with Jeff. He worked at in Auckland, New Zealand, and Miami, Florida, and South Peck Trust International with offices in the Cook Islands and Taronga, New Zealand. He has an interesting perspective on working at the trustee's office of these foreign trusts. We also have with us today Greg Zabailut, who is a former chair of the section, and he's currently, I think, Greg, you're also chair of the entertainment section now at Beverly Hills Bar Association. He serves as both tax manager and in-house counsel for Singer, Berg, Zimmer, and Kogan, LLP, where he works with high net worth and often high-profile individuals on a variety of tax issues, including tax planning, tax controversy, and tax compliance. I also want to introduce Gary Slavitt. Gary is a principal at the firm of Holt, Slavitt, and Drapkin, where I also work. He is one of the founding members of the firm. He has over 20 years of experience in civil and criminal tax controversy matters. He is a former IRS counsel attorney and has extensive tax court litigation experience. I am Michelle Weiss, the chair of the tax section, and I also am a tax controversy attorney at Holt, Slavitt, and Drapkin and a former IRS counsel attorney. And with that, I'd like to kick it off. So we're going to get four different perspectives today on asset protection and what it entails, what it involves, and why we go offshore. And with that, Jeff, I'd like to ask you to give us a brief introduction to why people go offshore and just maybe first a preliminary on the Pandora Papers and what they were about.
Sure, Michelle, thank you. And welcome everybody and to the panelists. As Michelle mentioned, our law firm based in Newport Beach and Silicon Valley focuses on comprehensive estate planning with asset protection for affluent families and business owners. I've been establishing foreign asset protection trusts since longer than I care to admit, 1989. And we find it has been and continues to be the most effective asset protection strategy for liquid assets that exists. So when Michelle contacted me and asked me if I'd be on this panel to talk about the Pandora Papers and asked me why people go offshore, I was delighted and honored and glad to be here. If you haven't heard of the International Consortium of Investigative Journalists, or Icij, this is an independent global network of 280 investigative journalists in over 100 media organizations spanning more than 100 countries. They're based in Washington, D.C., and they've got offices around the world. And what they do is they basically collaborate to do in-depth investigative stories, i.e. they go after the rich and they want to reveal what the rich do. Now, you may remember back in 2016, something called the Panama Papers, very similar to the Pandora Papers. In that situation, this organization was able to breach a computer at a law firm, Mossack and Fonseca in Panama City, Panama, and grabbed 11.5 million documents ranging from financial details to attorney-client information of more than 214,000 entities. That's some busy firm. The documents contained information about wealthy individuals, public officials that they had obviously wanted to keep private, Aside from outing some famous people like Hillary Clinton's BFF, Denise Rich, who was the ex-wife of tax cheat and fraudster Mark Rich, it revealed that she had over $20 million in her foreign trust along with her jet and her yacht. But aside from that, I'm not sure much really came in terms of revealing bad deeds or prosecutions from that reveal. Then on October 3rd, we had the Pandora Papers. 11.5 million documents were taken. They're not revealing how they got them. And the leak exposed the secret offshore accounts of over 35 world leaders, including current and former presidents, prime ministers, heads of state, and 100 billionaires. Again, it's too soon to tell, but we don't really know if what they learned about these financial affairs of these individuals are tantamount to violations of law. I suspect in all those documents are going to find something, but I don't know that it's necessarily going to prove that just because people go offshore, they're bad people. They estimate that between 5.6 trillion, $32 trillion rests within those offshore entities. I don't know how they could possibly know that, but that's what they reveal. When you look at the stories about this latest breach, you begin to get a sense of the ideology that permeates the reasons why they do this. In one quote that I read, real estate is a stable investment that often appreciates in value, of course, but by purchasing property through shell companies, buyers can secure certain tax breaks and shield their identities from law enforcement authorities and creditors. Well, duh. I mean, if you have a lot of money and you don't want people to know where your assets are located because you don't want your identity to be revealed because of the safety issues and other issues associated with that, you're going to set up structures to do this. And these people can afford to hire the best that's out there. And this is the advice they get from their advisors. So again, I don't know whether the Pandora Papers are going to wind up becoming the greatest reveal that ever existed, or whether it's much ado about nothing. Time will tell, but it's certainly interesting and makes for good press. Now, why do people go offshore, and who goes offshore? Well, honest people go offshore, and surprisingly, dishonest people go offshore. Although it's becoming more and more difficult for dishonest people to go offshore because of the ability of these trust companies, banks, and financial institutions and law firms to be able to determine who they are and what their backgrounds are. Seeking financial privacy is obviously very important, but as this organization has been able to do, they've been able to breach that privacy. So in my world, people go offshore to achieve the greatest asset protection that they can achieve for certain types of assets. It's not uncommon for an honest person who becomes dishonest after they've gone offshore to then have to deal with those ramifications. And it's not the fault of the advisors or the ecosystem that onboarded that particular client if they happen to change their spots and become a not so honest individual. Now, why do people go offshore? In my case, I was classically trained as an estate and trust lawyer. And in the mid-'80s, I was approached by some doctors down in Newport Beach where I practiced to do some asset protection planning because they wanted to retire. They couldn't get tail insurance 5 years after they retired. And these were doctors that delivered babies for a living, and they were going to be on the hook for those for their tort liability if there was a problem until the last child they delivered reached the age of 18, plus the statute of limitations, which took these fellas into their 80s. And that was just not acceptable. So in those days, in the mid-'80s, we had one tool in our toolkit for asset protection, and that was a family limited partnership relying upon the charging order. Well, after doing these for several years, and we had a few of these structures tested, I found that there were significant vagaries in our legal system because certain judges didn't care what the charging order law was. They were going to allow the creditor to invade the LLC, or excuse me, the LP, and get the assets. So I needed something more certain about the protections that we were going to offer our clients. And in the late 80s, there was an article that appeared in the Economist magazine written by a lawyer named Barry Engel, who really we credit for the offshore trust industry. We lost Barry a couple of years ago to cancer, brilliant lawyer. And what Barry came up with was a structure whereby a foreign trust would be formed. The trust would form a limited partnership. The trust would be a 99% limited partner, and the client would be the general partner, and he would fund assets into the partnership. And if there was a problem down the road, the partnership would be liquidated by the trustee and all the assets would dump into the trust. It would be offshore, and then you deal with all the rigors that a creditor would have to deal with if they're pursuing assets in an offshore trust. And that structure would often, at least in our experience, be the one component, the one certainty where the creditors would rather settle than to litigate with an uncertain result. So asset protection, again, is a big reason why people go offshore, but people go offshore because they're trying to find a better place to do their business. The IRS wouldn't print all the forms that people have to file, or US taxpayers who have affairs offshore, if going offshore were illegal. You just have to tell the IRS you're doing it. Then when you look at the evolution of the state asset protection laws, which started in 1997 in Alaska, Nevada became the second state in 1999 to adopt self-settled spendthrift trust law. There's about 20 states now that have some form of asset protection law to compete with these offshore jurisdictions. The states that have this law are smaller states. The big states like California, New York, Florida, they don't have asset protection trust law. The smaller states did it in part to generate revenues for their, for their citizens. But when you look at the system that we have in our country, you've got, the federalism system where you've got the federal laws retaining certain rights and the rest are delegated to the states. You have a lot of inconsistencies in the way the judgments are enforced. Does a California judge really care what the laws are in Nevada if you happen to set up a Nevada trust when you're a California resident? We don't know that yet. If you file for bankruptcy, you're forced into bankruptcy within 10 years of setting up your domestic asset protection trust, the bankruptcy trustee has up to 10 years to claw back that transfer as a fraudulent transfer to a self-settled trust or other similar device. So you just can't generate the predictability from your clients when you're relying upon domestic law, in my opinion. And my friend Steve Oceans may disagree with me, but in my opinion, that you can, when you have your affairs offshore, you get that jurisdictional arbitrage where the laws of the foreign country do not recognize judgments coming from the United States. And that will then foster a more robust settlement environment, which is what we're seeking for our clients. So I think I can close, Michelle, by just indicating that, going offshore is not unusual. It's not illegal. It should be part of any planner's toolkit. If they do it properly, they report it properly, and they know what they're doing. So I guess in a word or two, the Pandora Papers, while it makes for great press and it's interesting to see what rich people are doing, they're doing it for a reason. And I don't think those reasons are necessarily dubious. Thank you.
All right, thanks. So Greg, you have a slightly different perspective on why so you deal a lot with celebrities and high net worth individuals, and why do you how are your clients finding these ideas and these trusts to these investments to go into? And from your perspective, how are they finding their way to it, and why are they doing this? Is it similar to what Jeff had to say? Do you have a different perspective on it?
No, I think it's kind of in many ways similar. How do they find their way to these things? Usually through the people they work with, the agents, the managers, the attorneys, but a lot of times through friends. One person invests and it's for those of us of a certain age, it's like the old PERT commercial. I told two friends and they told two friends and so on and so on. And that's really how it runs. You hear clients, we have clients that call in with investment opportunities that they've heard about through another friend and they want us to look into or give them some more advice about, or is this legitimate? We've seen all different kinds of quote unquote opportunities, which may or may not be legal or not legal. Most of our clients, because they're high profile, they're not really looking to get in anything that's too shady or risky. In fact, we're all familiar with conservation easements, and we had a couple of our clients get approached by vendors who were promoting these things, conservation easements. And so as soon as we said this is a hot topic for the IRS to audit, they all started backing away, and not slowly. They backed away quite quickly. But when they do look into these types of investments, at least initially, their first thought is, how do I save taxes? Because for most of our clients, they're in a 50% bracket. Once you add the federal and the state brackets together, they're paying half their income in as taxes. So they're always looking for, what can I legally deduct? What can I legally invest in? Something that's going to get me some kind of income that I'm not going to lose half of it to the government. You get the very high net worth people, the Tom Hankses of the worlds, and they tend to get into things like tax-free munis, but more the lower end, if there is a lower end to people who are worth $5 or $6 million, they're looking for all of the benefits that they can get. So that's generally where it starts. Now, where it goes through is they find out very quickly that a lot of times the tax benefits are limited, if anything, and they can't get the tax benefits they want. But there may be subsequent benefits, as Jeff mentioned, the privacy benefits, right? So they own 2 or 3 homes. They don't necessarily want their name on title. And I think we could cite many examples of celebrities who've been assaulted or killed or stalked or swatted for reasons why you don't want your address out there, not because you're trying to hide something from a spouse or a creditor, just necessarily because some of your fans are a little bit more rabid than you want them to be. And even some of the other high net worth people we have, the doctors, the attorneys, some of the attorneys we have are well-known attorneys in the legal field. Again, privacy issues are for them. And then sometimes we've got people that want, that have high estates, and they want some way, can I transfer wealth? And so they look into these objects as, how can I transfer wealth without getting killed on taxes as well? So those are generally the things that they look at. And when they use trusts for all different reasons. If you've read any of these articles where they've named celebrities, by the way, none of which are U.S. celebrities, right? Elton John is, well, I mean, you could say the U.S. citizens, but primarily Elton John has a lot of interest still in the UK. Claudia Schiffer still has a lot of interests in Europe as well. When they're looking at these things, they're doing it through companies, partially for tax reasons, again, but not our tax reasons. In the UK, it sounds great to say there's a 19% corporate rate, but there's a 45% individual rate. That's the maximum rate. And you get there at $150,000 of income. So they may look at these on a foreign side because they don't want to get hit with that tax, and they can do it as a better structure. But by and large, I think Jeff hit a lot of the same points. This isn't people looking to arrange their affairs to avoid taxes. It's tax evasion, right? Was it Learned Hand, I think, that said that everybody has the right to arrange their affairs to pay the lowest taxes possible. And this is the real life manifestation of that saying. They're looking at what they can do to legally save taxes. And if you get another benefit like protecting your assets, so much the better.
All right. Gary, do you want to just touch a little bit on just what the compliance requirements are and what the IRS's perspective is on all this?
Sure. So my practice is primarily dealing with the problems, dealing with the audits when the IRS comes and thinks these are not such great vehicles for taxpayers. And Jeffrey mentioned that, they do it for asset protection, which is true. And Gregory mentioned some tax savings. The IRS seems to think that everybody offshore is doing something bad, is doing it for tax evasion. So it's often my role to come in and to provide information to the IRS and explain that my clients are doing this for legitimate reasons. Of course, there are some situations where clients are not doing the right thing and hiding money offshore. And with respect to the Panama Papers and the ones we're talking about today, the reason why there's not a lot of I believe there's not a lot of U.S. taxpayers in there. It appears we thought there would be in the Panama and the Pandora Papers, but there are not, and some scholars are saying, well, maybe it's because the U.S. tax code already favors the ultra wealthy with long-term capital gains rates, and maybe this is they don't need to do it anymore. And also, I think it's because the IRS has really stepped up enforcement and has done a successful job scaring a lot of people and making them understand that if you're going to go offshore, there are a lot of compliance requirements. And Jeffrey does a good job in an outline, I think that's attached, listing out at the end of the outline that he gives his clients, I believe. And Jeffrey, is that in the outline that we're providing?
Yes, it is.
It's a tax compliance memorandum, and it's 5 or 6 pages long, and it's very summary. I don't mean that in a negative way. There's a lot to tell his clients and to tell taxpayers who are moving their assets offshore, and the compliance requirements is very burdensome, and taxpayers need to find a competent CPA who understands all of these compliance requirements. Because what we see is a taxpayer going to a firm like Jeffrey's, intending to do everything in compliance, doing it for mostly asset protection, intends to pay all their taxes, but then they go to a CPA, and the CPA has a hiccup on one of the forms or 2 of the forms, forgets to check a box. Then the IRS comes in and audits, and the IRS immediately, my experience, immediately has a presumption that this is for tax evasion, not even tax avoidance, when a lot of them, most are doing it for asset protection. And so, it is, taxpayers that do these offshore, programs, trusts, corporations, perfectly legal, perfectly legitimate reasons to do them. But man, you better make sure you have a CPA that understands all of this, and so that you remain so that the taxpayers remain compliant. There's all kinds of forms. I think a lot of you on here are tax attorneys and are familiar with this. But there's a 5471s, 5472s, 8890, 8938s, 3520s, 3528s, and what are all these forms? If you have an interest in a foreign corporation, if you're the grantor of a foreign trust, if you're the beneficiary of a foreign trust, all of these, what the IRS calls information returns, right? Why are they information returns? Because no taxes are due on these forms. You just got to disclose this. And these forms, as probably most of you know, or many of you know, have very heavy penalties. And the penalties, often are very draconian, and we're often fighting, to reduce those or remove those. And the IRS is, it's still the biggest issue for them, international tax compliance. They've even set up a group, maybe a year or 2 ago, in the criminal investigations division called the Tax Compliance Group. It's a group basically of special agents that have specialty in international tax law, and their job is to do a lot of data mining. The IRS, I think, started using that term a few years ago, data analytics, and they're getting programmers to run programs to determine who to audit. They already be looking at the Panama Papers and Pandora Papers, but it's not clear how many U.S. taxpayers are in there. They're looking at all the FATCA information, right? Because I think there's something like 70,000 financial institutions complying with FATCA and providing the IRS information. So the IRS has a lot of information, and they are mining that, and they are going after it civilly. We're seeing criminal cases. Just I think in September, I saw a couple of criminal cases on the international area. A couple, also the attorneys, have to be careful, promote who the IRS calls promoters. They're going after bankers. So the IRS is very aggressive in this area. And, for those that are offshore for legitimate reasons, which many are, it's very important to be in compliance with all the compliance requirements.
All right. And Craig, I know that you worked on the other side, on the trustee side, and can you just give us a perspective, because Jeff was, I think Jeff and Greg and Gary have all indicated how people go offshore, they're not for nefarious reasons. They have good intentions, they're good people. And can you just explain the process of what happens once someone decides to go offshore and engage one of these trustees?
Absolutely. Let me start by saying I worked for two foreign trustees. I worked for one that's primarily based in the Cook Islands. They have an office in New Zealand and an office in Nevis. Most of these foreign jurisdictions, if I could back up a little bit, have a niche. They do what they do. And the reason Jeff and I typically use the Cook Islands is because of the statute Jeff alluded to that was drafted in part by Barry Ingalls, is specifically tailor-made for asset protection for Americans. And it does it wonderfully well. Now, I know all of the trustees. Well, let me also add that the second trust company I worked for, it was a much larger company. It had about 60 offices in 40 countries, virtually no American clients. So I'd say that the US persons that are going offshore, especially when they come to our office here, are looking specifically for creditor protection. We are not promoting, nor are any of our referral sources, as far as we know, promoting tax advantages to going offshore. Omnicorp, on the other hand, the bigger company, the non-US tax persons, a lot of times that's exactly what they're looking for, tax deferral. They come from countries with a tax regime that doesn't recognize income until it's repatriated. So if you have a foreign company earning foreign income and it's not in your taxing jurisdiction, you don't get taxed till you bring it back. So just simple tax deferral, obviously you can see the value in that. If you put 100,000 offshore and it makes $3,000 and in the USA you're taxed on it there, and if you have it overseas, I'm sorry, in your home country you're taxed on it, overseas it's not, it's going to compound much faster. So that's what they're looking for. And privacy, a lot of these, the non-US person's privacy becomes much more important. A lot of our clients were Latin Americans, and the Latin American wealthy people are genuinely afraid of being kidnapped. So there are all sorts of reasons people go offshore. But with Americans that come into our office, we are selling 100% creditor protection, and that's it. Gary mentioned something called FATCA, kind of in brief. FATCA is the Foreign Account Tax Compliance Act. It was passed in 2014. And what FATCA does is it requires foreign financial institutions to report to the IRS in the same manner that American financial institutions do. So if you put money in Bank of America, for instance, and it earns an income, the IRS is going to get notified by Bank of America that you have income, and it better show up on your 1040 or you'll notice. Foreign banks historically didn't have to do that. If you had money overseas and it generated income and you didn't report it, well, oops, But now under this FATCA regime, any income earned in any of these foreign accounts is going to be reported. And FATCA has been so ridiculously effective that even Russian and Chinese banks have agreed to be in compliance with FATCA. So it's very difficult to hide money these days. It's almost nearly impossible. But to answer your question, from the trustee's perspective, both trustees I work for would not take on a new client. They wouldn't onboard a new client without assurances that you are presently in compliance with all your tax obligations, and that you're continue to remain in compliance. And they notice, they have to sign off on the tax returns. They know if what you're filing, and they know if you haven't filed something. So the trustees don't play that game at all. And I would also say that the regulators in these jurisdictions are surprisingly effective. Most people from the United States will just kick back and go, these little island jurisdictions, what do they know? The regulators showed up in the office and they have teeth. If you're doing something wrong, they will let you know, and you can get in serious trouble from the trustees' point of view, and they won't do it. The trustees are try and run as clean a ship as they can. I'm not going to insult anyone's intelligence and tell you that nothing nefarious ever happens with these foreign entities. But I would tell you, if you audited all the entities that are set up in Sacramento, I suspect you'd find as much nefarious activities going on with these domestic companies as you do with these foreign ones. And the domestic jurisdictions really aren't taking extraordinary steps to weed out money laundering like the foreign jurisdictions typically do, at least the ones I've been associated with.
Michelle, interesting dynamic that's developed over the last 10 years or so. All these regulatory changes have had the maybe the intended or possibly unintended consequences of not necessarily scaring away Americans from setting up these structures, but they spooked the trust community. the ecosystem of trust companies, lawyers, banks overseas, they were pretty, they pushed back against the United States because they served a very important function for their clients around the world for really generations. But now, if somebody who wanted to just get into the industry, into the asset protection trust industry, wanted to develop a relationship with a foreign trust company to onboard their clients with a foreign asset protection trust, they're going to get a lot of pushback from the trust companies because they've gotten very paranoid, either reputationally or that something's going to happen with their regulators. But it's very difficult now for us, and I've been doing this over 30 years, but somebody just start getting into the industry is going to find it very hard to get the trustees and the banks to accept their clients because of all the data that's out there on their individuals. So maybe the government always intended for this to happen, but I thought the pushback would come from maybe a decrease in the demand, but the demand is even greater now because of all the political uncertainty that's going on in this country. But to try to get clients accepted by the foreign industry because of these regulatory changes, it's really become much more difficult today than it ever has.
So Jeff, Craig, and Greg, I'll throw this out to the three of you. Like, do you have a certain vetting process that you go through, or has it changed over time, or what does a client need to do? When they come and they say that they want to get involved in one of these foreign asset protection trusts?
Well, at Singer Burke, we have a wealth management department that is handling a lot of the investments. And if we are familiar with the investment, if we've dealt with Jeff, say for example, and somebody comes and says, "Well, I want to invest with Jeff," we know what Jeff's vetting process is, and we know what Jeff is and what he offers and the whole game. So that's going to be pretty straightforward. We already know. If not, then we're going to look into it to the extent that we can investigate it to get a sense of what it is that they're talking about, or what they're interested in doing, and try and put it through some sort of vetting process where we feel comfortable coming back to the client and saying yay or nay on it. If not, then we kind of give them a lukewarm response and say we can't say this is good or bad because there's not enough information out there, which we would hope would serve as kind of a warning, proceed at your own risk kind of thing. Because some people get very headstrong. We've had clients that want to invest in a restaurant, even though all of us know how bad restaurants do financially. 5 years in a restaurant's a good long time. They still want to invest in it because they think it's a great idea. So you can always try and do what you can for your clients, but you can't always dissuade them of something that they've set their minds they want to do, whether or not it's good or bad. But so we generally, and our regular clients, we have a pretty good sense of where they are financially and whether or not that would make a good investment for them as well. So we can also look at it from their point. We know what they are trying to accomplish, and is this really the best way, or is there another alternative that may be cheaper or more efficient to do that?
Michelle, it's also very important for people who want to get into this industry to make sure they deal with a reputable trust company. Because what will typically happen is the creditors will seek discovery from the trustee on what process they put the trust through when the settlor of the trust wanted to do a particular investment or investments. And I was involved in a case a few years back where I was an expert witness involving a significant amount of money. It involved an Alaska trustee, and the creditors have the money to afford to hire the best lawyers, and they really did a very thorough proctology exam of everything that trustee did to support that they weren't just rubber stamping what the settlor wanted, but that there was actual thought and deliberation and consideration by the fiduciary. So if you wind up getting a trust company that will do whatever you want them to do, it's probably not going to work if it's ever challenged. By work, I mean protect the trust. Whereas if you deal with a trustee that's going to ask for backup and data and business plans, it's going to be frustrating to the client. And of course, they can't get their money out of the trust as quickly as going down to the ATM, which also frustrates the client. But you have to do it right and follow the letters, follow the documents, follow the process, follow the procedures if the structures are going to work. And so you really have to educate your client on what they're getting involved in. And Craig and I, we probably wind up sending more people away who really aren't appropriate for this kind of planning than the ones that are.
And I would say that the trust companies dig deep. They do a very thorough background in vetting. They've got
Craig, you've got an interesting
resources.
perspective about what happens on the other side when you were with the trust company in the Cook Islands. You might share with the viewers, what was the process when they would get served with a lawsuit or a subpoena, or what happened on the trustee side that would often dissuade the creditors from pursuing claims against a foreign trust?
Under Cook Island law, the International Trust Act provides that Cook Island trustees, and I'm talking about just Cook Islands here, but cannot pay any attention, for lack of a better term, to any foreign process at all. So if they got served with a subpoena for records, they would just summarily ignore it. If they got served with a writ of execution, they would just ignore it. There really is not a terrific way for someone stateside to exercise, or there's no jurisdiction over these companies. That's part of how it works. So whatever the laws are in a foreign country, an American-based judge would have a very difficult time making a foreign trust company do anything. Now there's the issue of contempt on this end. Hey, Mr. Judgment Debtor, you better get your friends over there in the Cook Islands to pay this creditor some money right now, or you're going to jail. They can't enforce that because there's the defense of impossibility. A judge can order you to go to Mars, but you're not in contempt for not doing it. It's impossible. So that's old and settled law. It's what I would recommend, what I would do, and I did some litigation before I got into the estate planning business. If we got an order from a court, and I saw those sitting in the trustees' offices, letters from the judgment debtor demanding that their money be paid over to the creditors. If I'm representing someone here, I would say, well, the judge ordered you to do everything you can to get your money from that trustee. Do it. Do whatever you can. And we would get letters, pound the table and stamp your feet and do whatever you want. And, dear trustee, I've got this judgment against me, pay this guy. And we'd send a letter back, sorry, can't help you. And the client would go to the judge and say, look, here, I tried, here's all the correspondence, and they won't do it. Well, what do you want me to do? And there really is nothing the American court can do. If you've got a foreign trustee with a foreign bank account, it's just extraordinarily difficult to collect on that judgment.
So, Gary, what would you say if you were working with a client who had an IRS collection matter and they have all these assets in the foreign trust? Do you think you would be able to prevail with the IRS saying that it's in the foreign trust and that I have no way to access it? Or would getting one of these letters that Craig talked about be helpful? Or what do you think about that?
I think it depends what you're trying to do with the IRS. If you're trying to do an offer in compromise, you're going to have a problem. An example I have when I was at the IRS, somebody submitted an offer in compromise and did the right thing and disclosed that they're the beneficiary grantor of these foreign trusts, but we can't get the money. And so if the IRS can't get it, the IRM and the offer manual basically says, don't consider it. Well, there's a catch-all in the IRM and Internal Revenue Manual, which is the rules the IRS follows, especially with offers and compromises. There's an exception for public policy. And so the IRS can deny an offer and compromise for public policy. And I was a young lawyer at the IRS, and I was reviewing every offer over $50,000 had to be reviewed by a counsel lawyer. And I was reviewing this offer and compromise. And to me, it seemed like, well, we should approve it. It looks like it meets the rules. I was only supposed to review it for legal sufficiency, and it seemed to meet the rules. And my manager at the time overruled me and said no. And maybe I wasn't aware of the public policy exception at the time, probably. I wasn't aware that was my job to determine public policy, but my manager overruled me, and so we're going to deny a public policy. And I'll remember the revenue officer in that case was actually pushing for it to be accepted because there was going to be a lot of money given for the offer. And I remember having a meeting with the revenue officer and the manager, and the revenue officer was actually advocating for the taxpayer to accept the offer, but it got denied for public policy. So if you're doing an offer in compromise, it's worth trying because technically, if it's done correctly, as Jeffrey does them, arguably it's not an asset the IRS can get, and therefore shouldn't be considered an offer in compromise.
There's a case called Campbell, tax court case. I think it's 2017, where the taxpayer had set up a foreign asset protection trust years before he lost all of his money during the recession. He wanted to get an offer in compromise, and they refused. They went to court, and the court found that the fact that he had $5 or $10 million in his foreign asset protection trust, funded before he lost all of his money and became insolvent and couldn't pay the taxes, was not a reason for the court, for the IRS not to accept the offer in compromise. Very interesting case.
Wow.
I'm not aware. I'll have to look at that, because it seems to me
That's a great case.
it seems to me the IRS would only have, the tax court would be reviewing for abuse of discretion. And so it's hard, it would be hard. I'm going to look up that case after this, because it'd be hard for me to understand how a tax court, as long as the appeals officer considered it and said for public policy, it's hard to see how that.
Well, the underlying reason was the assets that are in the trust are no longer part of the taxpayer's balance sheet,
Right.
and therefore shouldn't be considered in deciding whether or not they should accept the offer in compromise. And that's the whole point
That's
of a
the-
foreign
yeah.
asset protection trust, is if the taxpayer doesn't, or the debtor doesn't report those assets on their personal financial statement, and therefore they're not his assets. And to Greg Redler's earlier point, that's why the trustee isn't subjected to having to turn those assets over to a judgment creditor, because they don't belong to the judgment debtor at the time the creditor comes seeking them.
But offer, I think the counter to that, and that was my conclusion as a young IRS lawyer.
You were right.
I excluded it.
You're well in advance of your years.
But offers and
It was
compromises.
only 5 years ago.
Offers and compromises are these unique animals. They're a matter of arguably administrative grace. The IRS can set up the program how they see fit, and there's this public policy exception catch-all. But I'm going to go back and look at that case, because that's interesting.
Jeff, let me bounce this off you. And this is, I never saw this as a trustee, but the way these trusts are designed, they're discretionary trusts. So if a beneficiary wants a distribution, they send a letter to the trustee. They can't demand a distribution. They have to, it's a precatory letter. Dear trustee, I know you don't have to do this, but gee, it sure would be swell if you give me money for XYZ. And what the trustee is going to do with that is they're going to look at the trust and make sure nothing in the trust deed prohibits that kind of distribution. And if they determine it's in the best interest of the beneficiary, they'll in all likelihood grant the distribution. One of the exceptions that's going to be in the trust deed is they're not allowed to make a distribution under duress. Duress being defined as some outside force compelling them to make the demand. A creditor is the classic example. So Jeff, for an offer in compromise, arguably that's voluntary on the part of the taxpayer. I never saw that, and it just might be an interesting way to.
Well, if your question is, can the taxpayer make a request of the trustee to settle an offer in or satisfy an offer in compromise with assets of the trust, where he's not being compelled to do so under duress, then I think that's up to the discretion of the trustee. And I would imagine in most circumstances, the trustee would use the trust assets to do that, all things considered.
We typically did make distributions on settlement, on voluntary settlements. So that we would do.
Yeah, but I think that the offer and compromise program, especially if you're under consideration with the IRS, it is kind of a duress. They could give you a requirement in order to enter into this program. You're going to have to meet X, Y, and Z provisions. And I've seen submitted offers that have come back where the IRS has wanted to know more about, can they make this payment, or can they do that, or can they borrow against an asset or whatever. So I think it's maybe not the same level of duress as a court coming in and saying, you have to do this. But, it's the IRS, and very few people are, they're going to feel pressure to acquiesce to that, even if you want to say it's a voluntary compliance.
One of the things, Greg, that we include in our letters of wishes is a statement under penalty of perjury that the request is being made voluntarily and not under duress. And a court can't make a debtor execute a document like that under penalty of perjury.
And I would say an offer in compromise is very voluntary, meaning.
No, but what if you're doing an offer in compromise in response to a CDP notice, for notice of intent to levy, I mean, that's pretty duress, right? Because if your offer doesn't get accepted, arguably you're now going to be levied.
I would say I never saw it as general counsel sitting out on Rarotonga, which is the big island in the Cook Island chain. If someone had a letter like that came in, they dropped it on my desk, it would be interesting.
I mean, an offer in compromise is viewed, in my view, as a contract between the two parties. And the IRS, Michelle, the IRS can never force somebody to enter in an offer as a collection alternative, nor an installment agreement. Those are just alternatives to levying, right? So it's an interesting issue. I mean, I would argue that from the IRS perspective, if the taxpayer can request the funds from the trustee to pay an offer in compromise, from an IRS perspective, I'd use that against the taxpayer.
But the whole point of the Campbell case was they weren't allowed to take that trust into consideration,
right,
in evaluating the offer in compromise and what his balance sheet looked like.
And I would be willing to bet Judge Halpern wasn't the judge on the case.
So what if it's a levy and not an offer in compromise? What if it's an IRS levy?
Clearly, that the trust won't distribute for that.
Clearly a duress situation. That's an agreement.
And the IRS is subject to the local rules with regard to debt collection anyway. And if the local rules don't allow for it because the Cook Island statute doesn't provide for it, I don't know how they're going to.
No, Jeff, I think you're right. I think that's what I think the big thing that I'm unclear about in the case you're mentioning and is the catch-all of you're right in all that, but this doesn't look good for an offer. So public policy denied. And so that's how at least the case I dealt with worked around it. And unless you're in a collection due process, you can't really go to court over that. Okay. The only way you get to court on an offer in compromise is through a CDP collection due process. And oftentimes offers are not submitted through the collection due process mechanism.
Well, we may have some people in the audience that have gone through this, and I'd be curious to see what their experience is.
And I think, part of the problem with this whole scheme of things, if you will, for lack of a better phrase, it goes back to what Gary mentioned a little while ago in the IRS audit standpoint, where the penalties for non-compliance are pretty stiff. There were 10 years ago, 12 years ago, there were plenty of people hiding money offshore. Today, with FATCA and FBAR and stringent enforcement, it's not. But we have these draconian $10,000 per year penalties on 5471s and up to 50% and on a 3520, depending on what we're talking about, that really lend an aggressive mindset to the auditor, right? You must be dodging, because why otherwise would these penalties be so stiff? And I think it then kind of permeates through to other people, the average layperson, that these penalties exist because people are dodgers. And therefore, if you're filing these forms, you must be hiding something. And I think one of the things that we keep coming back to over and over and over again is that people aren't necessarily hiding it. In fact, they're probably not hiding something. If we have 150 people apply, we might have one person out of those 150 people who's actually trying to hide something. And the other 149 have some very legitimate basis for going out and doing this. And stories like the Pandora Papers that are written to talk about was really, there's nothing there, right? That's, if you read these articles, it's so-and-so invested in real estate in, Slavonia or Gorgonia or whatever. And so what? So they're invested in Gorgonia and not, Alabama. I mean, maybe real estate's going up faster there and they have the wherewithal and the resources to get a better return on their money there.
Greg, you know where the biggest tax haven in the world is?
U.S.
Is it South Dakota? Is it South? I think it's South Dakota.
Well, it's the U.S. and South Dakota probably leads the field, but and then of course, Puerto Rico, another U.S. protectorate where there's tremendous tax benefits. The government wants to pass the laws, raise the capital gains tax. And what is that going to do? It's going to force people to look for structures offshore, like private placement, life insurance and annuities and other types of things, to lessen their tax burden. In 2017, when the tax laws were reduced, we collected more tax revenues than we ever did in the history of the country, over $4 trillion, when tax rates went down. So now the tax rates they want to raise them. What's going to happen? People are going to be forced to do extraordinary things to lower their tax burden that they otherwise wouldn't have done had the taxes not been raised, and that's going to affect the fisc. So it's all about tax policy, and it's typically where this, where these consequences find themselves.
And additionally, we keep mentioning FATCA, and FATCA was an American statute imposed on the rest of the world. And the enforcement mechanism is they kick you out of US dollar trading if you don't comply. And if you're a foreign bank, you have to trade in USD. So that's the enforcement mechanism. So the rest of the world was foisted with this regulatory regime from the USA. All of you foreign banks need to keep records of every customer you have. And if there's anybody that is a US person, which is much broader than a citizen, much broader definition, you need to make sure you give us this data, and we need to make sure you're taking adequate steps to identify who the US persons are. So you're the rest of the world, and you get this huge regulatory burden from the USA. What do? Well, what they did is they passed kind of a parallel structure, they being the rest of the world under the umbrella of something called the OECD, the Organization of Economic Cooperation and Development. And the parallel structure is common reporting standards under automatic exchange of information. So it's a statute that like 120 countries have signed on to, which basically everybody who's signatory to this treaty has to exchange data with one another. So if you're a New Zealand citizen and you open a bank account in Mexico, the Mexican bank is going to tell the IRD in New Zealand that you're a customer and here's how much money you made last year. So they know what's going on, but there was one notable exception, one country that held out, that refused to sign on to automatic exchange CRS. And I'll give any of you a chance to guess who it was. So when the USA was brought this treaty and said, will you sign on to this? They said, no. Do you know what that's going to cost our banks to comply with? We're not doing that. So you can open an account or open a trust in Nevada or South Dakota if you're a non-US person, and there isn't reciprocating reporting requirements.
Well, and there were plenty of instances where foreign banks that didn't want to get into this morass and this mess just told their U.S. citizen clients, thanks for coming, go bank someplace else.
I got a bag of mail when FATCA came down at South Pac. It was 300 letters. Dear trustee, or South Pac Trust is trustee of the XYZ Trust. Please be advised just that. We're no longer servicing American clients. You have 30 days to tell us where to direct the money, or we're just going to send you certified funds. We had to place like 300 customers in different banks around the world. Because of this one bank that did that, is Pictet & C, a big bank in Switzerland.
And the people that really got screwed by that weren't high net worth people. They were American expats living abroad who were suddenly unbanked.
Yep.
And I will also say that if they ever come out with Trivial Pursuit Tax Edition, Craig, you know all these acronyms, what they stand for. I want you on my team. I call Craig. You guys.
I would suspect they would sell exactly 0 copies of that.
Hey, Greg, I have a question for you. Has the Rust film situation and the potential liability that's going to arise from that, has that forced a lot of the people in the movie and television production industry to run to you to find out what they can do to protect themselves? Because the tort lawyers are going to be all over that. And a lot of people who are tangentially involved are probably going to be sued.
Not yet. But I will say that at our firm, when we get a client in, and we have been going through our existing clients for a while and making sure of this, we make sure that all of the things that make your loan out a legitimate corporation, right? That you have current minutes, that you have an employment agreement, that you have an operating agreement or bylaws, that you have all of those things in place, because you would be shocked how many people go out and they sign up for a corporation and don't do that. And some people who go through organizations like LegalZoom don't find out until they come to us that LegalZoom doesn't really do everything they're supposed to do. They leave off the California form about issuance of shares. They make you do that. They expect you to know that you have to do that. So we make sure on at least that standpoint that all of their corporate documents are in line, because that's their first line of protection. Is there a corporation? Go through the corporation, make sure it's a solid corporation. That's your first line of defense. And if you're weak there, they're going to be able to pierce the corporate veil, and then your assets are going to be exposed. So our efforts with our clients is to always make sure that we, to the extent that we can do that, we shore up the corporation to make it as very much a real, viable, legitimate third party as we possibly can, to show that no, this is not some kind of tax scheme. This is actually an ongoing actual business. And that at least is going to give our clients their first line of defense. And then will they come to us and ask about something like you guys offer? Quite possibly, but they tend to be people who don't do until they have to. And so if right now we haven't seen any actual lawsuits come out of Russ, we haven't seen who's getting sued or for what. I think the people who call themselves quote unquote producers, and we all know that that's a very broad term these days of what a producer is, those people are probably the most nervous, because now they're going to start wondering who of these producers are going to get sued, what are their roles, and then only when that starts to happen will they start comparing it to what they do and say, oh crap, I'm exposed, or thank God that's not me.
All right, well, we're just about at the end of the hour, and I actually don't see any questions. So I want to thank everyone for giving their own unique, interesting perspectives. It sounds like, from what we've talked about, that the Pandora Papers probably are much ado about nothing, and there are completely legal and appropriate methods of doing foreign asset protection using foreign trusts. If anyone has any questions, there are bios and contact information at the end of the materials. I'm sure any of the panelists would be happy to help you out and answer your questions. If you're interested in, oh wait, I see something in the chat. No, it's an announcement. If you're interested in getting involved in the tax section, please reach out to me. We'll be having a meeting of the section next week. And thanks again to the panelists, and thank you everybody for attending today, and have a wonderful day. Bye-bye.